SJC-13317, Commonwealth v. Juvenile.
Okay. I noticed that my sister is not yet present. Oh, here she is. Okay, we're all set. Attorney Menken. Good morning, Attorney Michelle Menken on behalf of the Juvenile. May it please the court. With the Commonwealth now having rightly agreed that Chapter 266, Section 5A includes a specific intent element, the main dispute for this court's consideration is whether there was sufficient evidence of specific intent on the record here. And we actually have an excellent record for making that determination. We have the Commonwealth's clearly articulated theory of culpability. The Commonwealth's theory, as stated by the trial ADA, was that the juvenile did willfully attempt the penny challenge, the TikTok penny challenge. And we have the judge's findings about what this was. And the judge here actually found that this was a prank, which may be what Justice Gaziano was thinking of in the prior argument.
I thought I was losing my mind.
The judge did.
I appreciate you correcting me.
Did state numerous times that the juvenile high school student was just being a prankster, and more importantly, that this was a wanton act.
But no, that's not really accurate, right? I mean, it was a wanton act with respect to the charges that were directed out.
That's right.
Right. So but didn't find that it was wanton with the ones that he was found delinquent on, because there's a different definition of maliciousness, malice, right?
Well, it was the exact same conduct. So
it was the exact same conduct, but I want you to be accurate in what you're saying. The court didn't say, with respect to what was found with delinquent, that it was wanton conduct.
Well, I can accurately explain what the judge said on the record. In discussing the malicious destruction of property counts, which she directed out, she said this was not malicious within the meaning of that statute.
Right.
This was wanton. This was a prank. That's what this was. He was trying to be a trickster. This is clearly wanton conduct. She said, I can't direct a verdict of the lesser offense, of wanton, because it's not a lesser offense. So I have to acquit him of malicious destruction of property. And so what we're arguing is that that determination that the conduct was wanton, clearly wanton, is inconsistent with a finding that it was intentional. Wantonness in the context of malicious destruction of property means heedlessly and in reckless disregard for the consequences. There's a case, Commonwealth versus Woods, in 2019 appeals court case, which talks about busting down a door, where the object was not to bust down the door, it was something else. The damage to the door was incidental.
Can I ask you about the impact of the fact that there are two incidences? So arson includes some type of scorching or charring of a structure, correct?
It can.
Okay. And then if we have, and there's evidence on the first time that at least the outlet is discolored or charred, correct, or scorched?
There was, yes.
All right, so then we have, he does it the first time, the light most favorable, he does it the first time, so wouldn't he know the second time that it's likely to occur by having been repeat offender, essentially?
So I have two responses to that. One is no, not necessarily, and the other is it doesn't matter. And I'll explain both. With regard to what was observable at the January 14th incident, the first incident, it's notable that the teacher who responded to the sounds that she heard in that area of the classroom did not notice any damage to the outlet immediately. It was only upon close inspection, about a week later, that she was able to see anything, and she did describe it as, let me find her exact words, I think she did call it blackening. I don't have those words in front of me.
Black charring on the outlet. and area around the outlet?
I think that was actually the second incident,
Right.
if I'm
Oh,
not
yeah.
mistaken. So
Yeah, I
we're
think
talking
the
about
second
first
incident is more severe, I
So,
think, right?
that's right. So, and we do actually have, this court has, in the record appendix of page 19, a photograph of the damage, and it's, I would characterize it as extremely minimal and difficult to notice. And that was not in evidence at trial, but the trial judge had done a motion to dismiss and did have that knowledge of what that damage was. In any event, it was so minimal that a juvenile special education student wouldn't necessarily recognize that that was anything more than a discoloration or a blackening, that there was actual damage to the structural integrity of the thing.
But the statute uses the word burn, right? It doesn't require you set fire. I mean, Commonwealth makes a big deal out of that, right?
Well, so I don't want to, before I get back to Justice Gaziano.
You know, finish up with him.
The question about, and it does kind of relate to yours, so the question about whether, this was sufficient is really a question of whether this was a completed arson, which is not really a question on the table. And in order to answer that question, I think it's important, if you look at the law about, superficial damage is sufficient. Pfeiffer talks about it. Pfeiffer is a case that's really important to resolving this case, I think. And if you trace it to the roots of that principle, the case that this was discussed in was a case where the attorney had come in with the actual piece of wood that had been damaged and tried to convince the jury that this was not actually enough damage. And what happened is the trial judge gave really thorough instructions, and I have them here, and described what the jury would have to find in order to conclude that there had been enough damage but that was not done here, that's not on the table here.
Your point, too, that you were going to make to me is one was...
It doesn't...
it doesn't matter.
It doesn't matter.
Tell me why it doesn't matter.
So it doesn't matter because certainly it is available to a trier of fact to consider what the defendant would have been aware of or likely would have been aware of in trying to assess whether that was the defendant's purpose to accomplish that thing that he should have been aware of. But the proof that or a finding that he should have been aware of a certain fact does not equate to a finding that that was his purpose. So while it might be evidence that the fact finder can consider, well, what would have been obvious? Should he have known from this prior incident that there could have been this damage, and would he have understood?
Isn't the purpose of this challenge to cause sparking and mayhem, essentially, with this conductive
That's
material?
right. And so what I would argue that you can find from the evidence, and you can find from I suggest the judge's findings about this being a wanton event, was that she accepted that this was an effort at a penny challenge, and that the goal of that penny challenge was to create sparks. And that's what...
Can I stop you on that, though, for a moment, though, because this is what I'm struggling with. Two things. The first one is, just because it's a prank doesn't mean, going back to the language of Pfeiffer, that where mere charring of some portion of their dwelling, here a public building, constitutes burning. So the fact that it's a prank doesn't mean there can't be a specific intent to cause some portion. And the second issue, which I think is probably more important floating around all of this discussion, is the judge doesn't say anything as to his reasoning on the attempt. And it's a bench trial. So we assume that he gave himself... She, thank you, Justice Gaziano, gave herself a perfect instruction.
Well, we actually have a record of how the judge instructed herself. We have it from the motion to dismiss hearing, and more importantly, we have it from the discussion of the directed verdict, and she makes findings, and she talks about what the law is on the attempted arson, and she gets it wrong. She says that you only need malice, and she describes malice as only a wrongful act without any excuse. She doesn't talk about what the juvenile should have known, what should have been obvious to the juvenile. But what we know about, so getting back to what the juvenile might have known, the evidence of what the TikTok challenge videos showed, the deputy fire marshal is the witness who testifies about having seen the videos and his knowledge of what the challenge is. And his language is a bright white light, like lightning, and sparks. And I think if you think of a sparkler, an ordinary sparkler, it is not a foregone conclusion that sparks mean fire or burning.
Yeah, so that was
I
my,
don't know about that.
Yeah. I mean, this isn't like a July 4th celebration where you give a child a sparkler and they're standing there as it burns down. I can't recall if this was a sustained objection that didn't come into evidence or not, but wasn't there some discussion of a conversation between the juvenile and what I think was a co-juvenile that they wanted a bigger spark? Wouldn't that be evidence that in fact they knew, or that the juvenile knew, that this could be something much more than just a prank, because they wanted a bigger result, a bigger consequence to this?
Well, but the consequence they were aiming for was bright light, like sparkle. And there was no discussion by any of the juveniles of, we want to scorch that outlet, we want to melt our own phone chargers. The goal was these bright lights, and there was no evidence that the TikTok videos displayed any sort of charring or any fires. The discussion in the record about the potential for fire came strictly from the fire marshal about sort of what he theoretically knew. And I think it's instructive that the fire department on the 21st, which was the day of the second incident, actually issued this advisory explaining that there's a risk of fire associated with this challenge, which I think is evidence that the risk was not obvious.
So doesn't that go to Justice Graziano's question about, in the light most favorable to the Commonwealth, what would the juvenile know from the January 14th incident that tells you about what the intent would have been on January 21st? And
could I follow up with that? Because there's one other piece to that. What is the judge to do in engaging what happened on January 14th to make of, he wouldn't even touch it? The teacher's testimony was that he was kicking at the, whatever it is, the
Charging block.
the charger prong, right? Wouldn't a reasonable inference be he's kicking at it because it's too hot to touch?
Sure.
Right. So now if you can answer that Justice Lowy's question about how that informs the next event.
What the judge can infer that the juvenile knew was that there would be flashes of light, loud noise, perhaps minimal blackening, which may or may not be a structural impairment of the outlet itself, and heat. So let's say that the judge found that. The question is, would the properly instructed fact finder be able to conclude beyond a reasonable doubt that his specific intent, his purpose, the motivation behind what he did was to burn the building? Even if you call burning the building a slight melting or alteration of the outlet, even if you say that, that's not enough for beyond a reasonable doubt. And we actually know that this judge was of the opinion that that wasn't the goal. The nature of the prank was not to damage the outlet. The nature of the prank was a light show. So, it's our position that the judge essentially acquitted this juvenile of the alleged conduct.
I think it's a really interesting issue in this case that we haven't talked about much in other cases, about at a bench trial what the judge says, how that impacts on whether the judge instructed himself or herself correctly. That sort of becomes an interesting issue in this
Well, it
case.
is, and in the case law cited in my sister's brief, it says, in the absence of a contrary indication, you can assume that the judge instructed herself correctly. Well, here we have a contrary indication because she says, this is what I need to find. It's malice, and this is what malice is, and I find that satisfied. And she didn't get malice right, and she didn't get Pfeiffer right because she did not make sort of or at least there's no indication that she made any assessment of what this juvenile should have known other than, this was a prank. There was another question which has escaped my mind. So I see my time is up. If there's no other questions,
Okay, thank
the
you.
rest of my brief.
Okay, Attorney Black.
Good morning. May it please the court, Johanna Black on behalf of the Commonwealth. So just in response, I'm going to start off with the judge's commentary on the juvenile acting as a prankster, committing a prank. You can't speculate as to what she meant by that. That would be improper, but you can look to the context in which she said it. And she said it in the context of discussing malicious destruction of property. And that's really the malice, the maliciousness, is the only element that the juvenile was actually challenging on the motion for directed verdict. The juvenile never raised the issue of intent, which, as we know, based on a number of sources, but in particular, this court's most recent decision in Pfeiffer, intent is separate. It's a separate element from malice and from willfulness in the context of attempt to burn or attempt to commit arson under Section 5A. So here, where the judge is talking about her feelings that the evidence didn't rise to the level of maliciousness under malicious destruction of property, which she was correct in saying is a completely different element from the maliciousness or malice involved in arson, which is the same as the malice involved in attempted arson, contrary to what the juvenile keeps trying to argue when she says the judge misapplied the element of malice. The judge did not misapply the element of malice. The judge, in talking about the evidence not rising to malicious destruction of property, was simply saying the juvenile was acting as a prankster. He was committing a prank, meaning he wasn't doing this out of hostility or cruelty to a particular individual, against someone. This is an attempt to set fire to or burn a building.
Well,
it's not out of hostility towards...
That's, I mean, your opposing counsel says the following. The specific intent here was to basically create the arc, the sparkle, not to burn or set fire to the building. And he's a kid and he doesn't think through things, but that's his specific intent.
That's the defense's view of the evidence.
How do you deal with that? Forget about malice and other things. His specific intent was basically to create the arc of light, which I haven't seen these TikTok videos. I'm just relying on what the record says they show, but they don't show the building burning, but rather sort of lights, sparks.
Well, so that's an inference that the juvenile draws and wants your honors to accept. That's the only inference that the juvenile wants your honors to accept. But there's so much evidence there that the juvenile is disregarding, and you can take all of that evidence, all the circumstances, all of the reasonable and possible inferences that you draw from the evidence. They don't have to be probable. They don't have to be inescapable. Inferences don't have to negate the inferences the defense wants you to draw. It's really, when there's conflicting inferences, as your honors know, it's up to the fact finder, and the fact finder drew inferences in favor of the Commonwealth. So with respect to the evidence, with respect to the first incident, yes, so the juvenile was performing the penny challenge. I don't think there's any dispute. And the juvenile was doing that on January 14th as well as January 21st. And we do know from the evidence, specifically the, I believe it was Miss McCuster, but one of the female teachers, as well as the deputy from the fire department, testified that they know that during the penny challenge, juveniles are pushing a cell phone charger into the wall, pulling it back, putting a penny on the prongs, and then jamming it back in to create sparks. And we know from the deputy that sparks are caused by a short circuit and electrical arc, and that short circuits can cause fires. And here, really, it's a mistake of judgment as to how much...
Again, we're dealing with these, our best evidence of what this kid knows is what the TikTok videos show. They don't, and it looks like they show just the arc of light. I understand, you know, but
But
we're
isn't
also
that
dealing with the-
significant in terms of setting a fire? He knows that by plugging an electrical piece, a cell phone charger, into an electrical outlet, he's creating what appears to be fire.
It's stupid as can be, but he's not an electrical engineer. He doesn't know anything about short circuits. He just knows, I'm going to show off to my friends that I can create this arc of light. Again.
Well, he
what's a
knows that the
reasonable-
penny melts, so he knows there's heat.
He knows what melts?
The penny.
Oh, the penny. In the videos, do they show the penny being a melted object at the end?
I believe the deputy describes that. Let me just double check.
I thought he described the actual penny in one of the incidents was melted in such a way. But just to follow up on Justice Kafker's point, all of that gloss is in the light most favorable to the defendant or to the juvenile, and we're looking at this in the light most favorable to the Commonwealth.
That's correct.
So at least with respect to all of the inferences that can be drawn from what the juvenile likely knew or understood, do we have enough?
I think so.
Do we have enough?
I don't think the juvenile needs to understand the intricacies of how a fire is caused. I think juvenile needs to understand that by doing this, you can cause a fire. And when you look at his actions, the fact he never called for help, you know, not to jump to the second incident, but he tries this again, not once again, but twice again. He knows these are sparks.
What do you mean twice again?
So on January 21st, it appears from the evidence that he attempted the penny challenge twice.
I see, okay. So twice on the 21st.
Right. And both times there was crackling noises, which sounds like a fire.
Counsel, can you help me with that piece of evidence again? I remember from reading from the record that I thought that was a conversation that was testified to between the juvenile and another juvenile about how they wanted. Was that sustained or was that overruled? I remember there was an objection. I can't, was if that was in evidence or not.
So in the police reports that counsel submitted with, or that the juvenile submitted with his brief, that conversation's contained. I didn't file a motion to strike, maybe I should have, but I figured at argument we could just sift through what you can look at and what you can't. Obviously the police reports aren't relevant to the issues because it's really a trial issue here. And then at trial, I believe the ADA, or 303, attempted to elicit that conversation, but it was objected to by the juvenile. I can't remember if the conversation in the police report would fall under defendant's statement or completeness of what the defendant's response might have been, if it was in fact admissible, but in any event, the objection was sustained and the conversation did not come out in evidence at trial.
Thank you.
So just as you were saying, the juvenile wants you to think that he was just trying to create a light show, but there's charring. There was charring to the outlet in the first incident, and the deputy said, the teacher, when she looked at the outlet. Sorry, I'm just losing my pages. Here we go.
Are you looking for what the teacher's going to observe on the 14th or the 21st?
The teacher on the 14th, when she went back a week later, I believe she said, sorry about that. It's, she said it was, I have it right here, sorry. She said it was charred. So the teacher on the 14th, when she saw the charger cube that day, said it was blackened, did not appear very usable, no cord was attached to it. Then when she went back about a week later and looked at the outlet, which was presumably the 21st, she saw that the outlet was charred and blackened around the bottom right socket. And the deputy himself said when he got there on the 21st, he initially looked at Ms. Bechtold's classroom, which was the classroom where the incident on the 21st occurred, but that he also went to the other classroom where the incident on the 14th occurred, and he saw during cross-examination, when you look at the questions and the answers he gave, the reasonable inference from that evidence is that the outlet from the 14th was charred as well. So you have evidence that it was charred. And one important point is that this is an attempt. It's not successful completion of arson. So
Yeah, except for, and again, I appreciate Justice George's point that I may be reading this in the light most favorable to you, but the whole point is this TikTok thing is you can do this thing, but you're not gonna set fire to your house. You're not gonna.
you are, though.
Well,
the
you
deputy
are-
says short circuits cause fires. If there's enough insulation, then they may not. But a mistake of judgment under Peasley doesn't negate an attempt.
I mean,
So
again,
the juvenile doesn't have to understand.
the videos are not introduced at trial, so we don't have the TikToks. We don't know whether they're sitting in their living rooms setting off these things and, getting a chuckle, or they're at somewhere else where they don't mind whether they burn down the house or not. We don't know any of that, right?
Right. I don't know if that really is that probative, though, as to
Well,
this
it is. I
juvenile
mean,
state of
again,
mind. But
it's a prank. It's a stupid one, but it's being encouraged by kids in a way that looks like it doesn't cause the kind of they're not setting fire to their own homes. But again,
well, you don't know that. That's not in evidence.
well, I know that the TikTok challenge produces an arc. That's what it does.
Electrical arc.
Right, and I read the fire chief's description. It doesn't say anything gets set on fire. It just says there's an arc.
That
of light.
also wasn't in evidence, though. Are you talking about the memo?
I was reading the transcript, page 40. I think it was page
Okay.
47. That's the transcript of this, right?
Yeah.
And he says it's like, but it's dangerous. He says it's like when you see on the streets where the wires come down and they're sparkling.
He says short circuits cause fires. That the amount of insulation or the amount of overloading to a circuit can affect whether it actually goes that far. But under Peasley,
Sorry,
that's...
How old was the juvenile?
How old was the juvenile? I believe he was 17, to double check.
So let's assume he was 15.
He was 17 because, yeah, I don't want to give too much identifying
All
info,
right, so- but still.
he was 17, I believe, just based on the probationary period.
Okay. And so we're to assume that a 17-year-old would know about a short circuit.
He might have
that
been
caused a
16
fire.
at the time of the
I
incident, I'm
think he was
sorry.
15, actually.
15? Okay, I apologize.
Year-old would have the acumen to know that a short circuit would set a fire absent sufficient insulation.
I think
Commonwealth's position.
I think all that matters is that you see an electrical spark. And it's what would a reasonable person think, seeing that electrical spark. And knowing that a penny melts, that there's charring, that suggests heat. I think a 15-year-old can
I'm sorry, just
infer.
to be, did he know that the penny would melt? Did that happen the first time or the second time?
The penny melted the second time. We don't know whether it melted the first time.
That's my point. If he hadn't, he wouldn't know that the penny melted until after it happened.
Well, he knows not to touch the prongs when the penny drops onto it. The
Yes,
deputy
but-
testified that the challenge is to put a penny in and
Understood.
jam
I'm
it
just
into the
saying
wall.
he
Don't
wouldn't
touch the
necessarily
prongs.
know that the penny melts as a result. Sometimes it happens, sometimes it doesn't. And there's no evidence that it happened the first time.
But electrical sparks looking like lightning,
No, that's fine.
I mean, that suggests, I think there's a reasonable inference that someone knows that causes heat.
That's fine, but a penny melting is different from sparks.
but they want the sparks, which is
I understand all
resembles
that.
fire.
That's fine, okay.
I still, counsel, also, it's significant to me, or at least it appears significant, that Miss Cusker, I think, sees him kicking at the cube. I think that's a big deal,
That he's trying to use his foot,
not trying to use his hand.
right, to protect his hand. I think,
He knows
you know,
it's hot.
defense wants to make it
He knows it's really hot, or he wouldn't be.
keeping a more sensitive
Right.
part away from it. And I also think, you know, the 14th and the 21st are separate incidents. You can look at what he learned on the 14th. You can look at what he learned during the first incident on the 21st.
And he's charged with both, right?
He's charged with both, one count for each. If I could just double check my notes, see if there's anything else I want to touch on. I also just do want to point out, the defense only talks about what a reasonable 15-year-old would think, or a reasonable person in a 15-year-old's shoes would think with respect to if this court doesn't find specific intent. The juvenile never raised that with respect to specific intent. And again, it's a sufficiency analysis. It's not a 33E. We're not looking to see whether the judge should have instructed herself with respect to specific intent, how a 15-year-old would view things. It's a sufficiency analysis where the evidence is viewed in light most favorable to the Commonwealth. We're not even reaching the issue of a reasonable 15-year-old because it's the crime-specific intent. It's not general intent like under Pfeiffer for the completed commission of arson. And again, the juvenile does raise, you know, issues about him having an IEP, an individualized education plan. All we know is that he was one of the students that required smaller class sizes.
I'm confused which way that cuts, what you're arguing.
I don't think it's
Because it's a specific intent crime for a 15-year-old with a learning, whatever that IDP plan's called.
we don't know why. All we know is that he was on students required smaller class sizes. We don't know, you know, was the individualized education plan based on any physical or intellectual disability, a sensory disability? We don't know. And that really, if it's a defense or it's evidence that would try to cut against the evidence from which you draw reasonable inferences in favor of the Commonwealth, you would think that'd be up to the juvenile to present, and there wasn't any evidence of it. We don't know what any of his disability or disabilities may or may not have been, the degree, how they might even impact his ability to understand.
But we can't assume we're talking about a 15-year-old as opposed to an adult.
Right, but it's a crime that's not specific to juveniles. And juvenile sentencing and punishment and the court system itself is geared towards protecting juveniles in a different way than adults. This crime does apply to adults too, so we can't just look at it through the lens and make decisions solely based on the fact that it's a juvenile involved in this case.